by politicians.
Yeah.
And in the course of doing this, the judiciary will become the fall guy, so to speak. And if things are not carefully managed, the judiciary may be compromised in the process. So it is a period that we want to urge the judiciary to be careful, circumspect, and remain focused, believing that this is a trying period for them, and be ready to resist all forms of temptations. But remain focused and make sure that the job is done, and done creditably well and satisfactorily, so that the Nigerian perception of the judiciary as a performing judiciary and a judiciary that can no longer be easily compromised will remain what it is, and of course will gain international recognition and acceptability as the case may be.
I know that you've said that we have the capacity to handle cases within a period of 7 months from the time of arrest to the time of judgment, acquittal or discharge, but we have much more cases that are not handled with dispatch. What are the things that we're not averting our minds to with regards to ensuring speedier dispensation of justice?
Well, I feel that a pattern has not been established, and it is that pattern that the prosecutors, starting from the office of the Attorney General and the prosecutors, are trying to establish, and they are doing that fairly well, and the test case seemed to have worked out, and much more, because it is a skill that can only be predicated on rules that will be put in place for such to flourish. The terrorism case involving the Lebanese has been successfully tested, that something can happen within so short a time. Now, we want that to be replicated all over. If we're able to achieve that, and with the support of judges at the same time, with the support of judges and the fact that there will be no room to frivolous adjournments and so on and so forth, I believe that that will help us. The bane of our judiciary and the bane of our administration of justice system in this country at this moment is the fact that cases are not speedily dispensed with. And whatever we can do to change that pattern will earn us a lot of recognition internally in Nigeria, amongst the citizenry, and more importantly, in the Committee of Nations. Because people now believe that because our judicial system is very slow, foreign investors are deterred from coming, and also the only other alternate or substitute is alternative dispute resolution. But even at that, we have since realized that even alternative dispute resolution is no longer what is as it's fast to be. By the time you have gone through the threshold of ADR, you now know that you are starting all over again, because that is when the matter goes to the High Court. And the issue of award is not seen as conclusive or having that breadth of finality, as the case may be. So we must also consider the economic implication of delay in administration of justice. And putting everything in totality, it is in our best interest to make sure that we develop patterns of ensuring that not only in civil cases, but also in criminal cases, that things are handled with dispatch and effectively and efficiently, as the case may be. So it behoves the judges, it behoves the prosecutor, and to a large extent the defense. But I know for sure that once we get prosecution right, together with the judges, we can achieve what we want to achieve. Because the two can push the defense to a point where they can no longer sufficiently and successfully extend the scope of a defense.
If you were to talk about specifics of what we must put in place to achieve that?
Well, what I mean by putting things in place, we must develop this pattern. And if need be, make it a methodology that somebody can say, you do this, you do that, you do that. And that's what they are being taught to do. In criminal cases, there are certain points you must have at the back of your mind. And people should also appreciate that criminal case is not restricted to just criminal law. It's much more than that. There are some other profound instructions that should come with it. And what I mean by this is that there are some extra legal knowledge that may be helpful to you. If you're a criminal lawyer and you know next to nothing about treaties in force in this country, and you are not capable of researching to know, and you are not good in researches in issues that are extra criminal, so to speak, then you are not supposed to be prosecutor. Because we have had instances where the issue will be, is Hezbollah a terrorist organization known by law? How would you know whether it is if you are not given to reading beyond the confines of your area of expertise for you to know whether Hezbollah is even an organization, and where are they located? Are they terrorist groups or not? So this is not what criminal law will teach you. Yeah. This is what you read beyond criminal law. So it is important that people understand that for you to be a good criminal lawyer, you must have at the tips of your finger certain information that may not necessarily have anything to do with criminal law, but they are also very, very tangentially related and incidental to you are having a very good prosecution. So these are specifics that we should be thinking about. So in terms of building capacity, one should say that in developing expertise in a particular area of law, you should be in a position to know that you should have to widen your horizon, that your vistas of the situation should be higher than that of other people in order for you to conclusively pursue a particular case to a logical conclusion. Failure to do that, then we're in a quandary. So these are some of the issues and the specific we should be looking forward to. And Judicial, as the skill and expertise of the prosecutor is also widening, so do we also expect that same for the judges, so that the scope of the judge should also not be restricted.
And same for the defense
and
counsel.
So for the defense counsel.
They'll come up with new tricks to
exactly. So you now find that people should know that law is not ABC, that there could well be DE that can impact positively on ABC if you are aware of ED. But if you are not, then that is the end of it. And that is the problem, where more often than not, defense counsels are seasoned counsel, very senior one, and they are also very knowledgeable. And more significantly, they are also open to research, because they can easily find young colleagues that can research for them. This is also the same thing we expect from the prosecution. Gone will be the days where prosecutors are very inexperienced young people. It is not good for our justice system, the criminal justice system in particular, for you to pitch young, inexperienced criminal trial lawyers against very seasoned people with all the arsenal at their disposal. It is a mismatch, and it doesn't make for proper and effective dispensation of criminal justice.
But then you've also talked about research and knowing your field and widening your horizon, reading wide and all of that. I've often heard the Nigerian Institute of Advanced Legal Studies referred to as Nigeria's premier law board. But as Director General, can you tell us specifics of what you're doing to aid the development of law in the country? I know that oftentimes you organize roundtable debates and conferences to talk about topical issues affecting the country. But beyond all of these talks, what really happens? Does the government even listen?
Our approach is a little bit different. I've had cause to say that we try as much as possible to look at law from a different angle. And the researches we conduct here, mark you, most of our researches are field researches, socio-legal researches, so to speak. In other words, we can look at our law from the perspective of forensic empiricism. And what I mean by this is that you have statistics to back up what you are doing. We conduct surveys, and they are live researches. So it's not a question of the opinion of an individual, or say, well, I imagine, I presume. It's not hypothetical, backed up by forensic empiricism, practical. And that makes for legal pragmatism to a very large extent. So the law becomes active. It's like law in context, law in action. And that is the beauty of what we do in Nigerian Institute of Advanced Legal. So we pursue law from that perspective. So whatever we do here is not the normal doctrinal research where you finish something, you put it in the cupboard. We test what we are doing. When we did our restatement of customary law and gave it the authority and the vitality that can make it become usable in courts of law as an authoritative position as far as the customary law of the people are concerned,